This is You and the Law on AM 650. Now back to the show.
Welcome back. Sterling Fox in studio with Scott Stanley and Kevin Gorley from Murphy Batista on this edition of You and the Law. Murphy Batista LLP, a Vancouver firm that works in the field of insurance claims. And Kevin, I wanted to talk to you. This came up during the break when we were just talking a few minutes ago. The whole matter of bad faith. And I brought it forward and Scott said, oh, that's Kevin's specialty. So what is bad faith and how do you combat it?
Well, an insurance contract is known as a contract of good faith because it is intended to protect you when you're at your most vulnerable.
Okay.
So it's whether your house is burnt down or whether you've become disabled and can't work, it's supposed to be there for you when you need it. Both sides of an insurance contract have to act in good faith to the other. You have to be honest with your insurance company when you're applying for coverage and making a claim. And they have a duty of good faith to assess the claim fairly and not just look out for their own best interest. There was a very recent case out of Saskatchewan a couple weeks ago where a person was disabled and the insurance company just delayed and delayed and delayed for, I think it was about 9 years. They knew they ought to pay this guy, but they were trying to essentially wear him down. Ultimately, the Saskatchewan court found that the insurance company had acted in bad faith and awarded $4.5 million in what they call punitive damages to punish the insurance companies. That's by far the biggest punitive damage award in Canadian history.
I guess, can I interrupt you just
Sure.
to ask only how did it last 9 years? How could it not? How could the courts have not been brought about to intervene in a shorter period of time? That's a long, long time for a guy to be banged up and miserable, isn't it?
It is, and I don't know the details of that claim, but often what you find with disability claims is that the disability companies will string you along with internal appeal processes. They will say, we've denied your claim now, but you can appeal your claim, get us more medical information. Oftentimes you find on these appeals, it's the same people who are reviewing their own decision and almost without fail come to the same conclusion. But they can string you along thinking that there's going to be some sort of outside objective body looking at these things, and usually there isn't.
So this insurance company got caught acting in bad faith, basically trying to wear out a claimant rather than just writing the check that should have been legitimately written eons ago.
Yep.
And how frequently does that happen?
It's quite rare, and that's one of the few weapons essentially that an insured has when they've got an insurance claim that's been wrongly denied. If the only thing that is going to happen at the end of the claim is you're successful and the insurance company has to pay the benefits they ought to have paid up front, there's really no incentive to the insurance company to pay it now when they can just wait, and if they lose, they pay later. So the threat of punitive damages is one of the few weapons you have to make them pay now so that they don't have to pay more later.
Scott, when we were taking the break, our producer, Art Factura, jumped in and talked about a situation that he'd been in a while ago. And this is pretty common stuff. He was involved in a rear-end traffic accident and advanced a claim. They offered him a small amount, a few $100s, and he thought he wasn't particularly wounded or banged up or in distress. And he thought, well, what the heck? Okay, sure, I'll take your money. And that was the end of it. Is that a standard procedure? If the insurance company thinks there might be some substance to this claim, that they'll offer a small amount of money, a carrot, if you will, hoping that maybe the person will take this relatively small amount of money and disappear?
Well, they're like Monty Hall. They're always wanting to make a deal.
Okay.
And they want a good deal. They're like my grandmother. She always wanted to get a good deal on things. She could have run an insurance company quite well. But they do that. They offer these carrots or these incentives. And giving an example, I had a client who was on disability long-term. He had Crohn's, and he was a plumber, and he was never going to work again. That was quite clear. And so he was a young guy when he went on the disability claim, about 25, and had a young family, wife that didn't work. And every time, for 4 years in a row in October, they'd cut him off his benefits.
I just to understand, how would a young a tradesman, who would be his insurer? Would it be some provincial government thing, or would it be a private plan through his employer?
Private plan through the employer.
Okay, all right. Just wanted to understand that part. Okay.
Private plan through the employer.
All right.
Every October, they'd cut him off. They wouldn't give him any money leading up to Christmas. So October, no money. November, no money. And then December they'd say, well, we're not going to pay you any money, but if you want, we'll give you this check for about 10% of what his claim would have been worth over his lifetime. If you sign these papers, we'll give you the money now in time for Christmas.
Right. Right. But part of signing the papers meant this is the end of the claim. You will disappear for good.
They did that 4 years in a row.
Really? And he resisted each time?
Resisted each time.
Wow. And but what a nasty bit of business to hold back on payments and then offer a carrot instead of a settlement.
Well, it's not nice. It's not nice.
But it's I gather, as I've been doing a little homework and getting ready for you, this is fairly commonplace. Offer them a pittance, and if they accept, we're done. Next.
Well, you starve them first, and then you offer them the pittance. You make them desperate and vulnerable, and then you offer them a pittance.
And Kevin, how difficult is it in some cases to convince a person who's really hard done by, who may be disabled or badly injured and desperate for some cash? I can't work. There's no source of revenue here. I'm flat broke. I'm relying on my relatives. This is gross. So they're offering me some money. Damn it, I need this money. How tough is it for you to say, look, don't take the money. If you just play this thing through to the end of the game, there'll be a lot more in it for you. How do you convince that person who's in dire straits to be resolved?
That's the conversation you have to have with clients very commonly. And it's a difficult one because if your house is burnt down or if you don't have any money coming in through the door, what do you do? Do you go on social assistance? You get EI. But when the insurance company is trying to starve you to get you to take 30 cents on the dollar, 50 cents on the dollar, all you can do is do everything you can to hold out and get at the end what you're entitled to, and what you paid premiums for is frankly what it's about.
Well, they make you feel like you're doing your client a favor, and they can be so pious and sanctimonious about it when they say, here's what we're offering your client. And Murphy Batista, we basically say, no, here's the deal. You either give us what we ask for, or we're going to go take it from you.
Right.
We're going to get what our clients deserve.
Okay. Now, again, I'm just trying to put myself in the position of the client. Again, and not in the best of shape. And I'm sure some people come to you and they're pretty distressed and pretty messed up and pretty desperate. So, it's standard operating procedure for the insurance industry. Offer them a pittance. How do you convince people who need that pittance to survive not to take it, Scott?
Well, you basically just have to make sure they've got confidence in you.
Okay.
And you remind them that they ought to have good confidence in our courts because we've got the best court system in the world. And you have a chat with them. You put them at ease. You don't keep them in the dark. You let them know what the process is going to be all about.
And do you say to them, don't take this money. They're trying to starve you. This is 5% of what you deserve.
We can't say that, unfortunately. We can't tell the client what to do. Bear in mind, it's like going to a slot machine, Sterling. The client gets one pull at it.
Right.
We can sit there all day and pull as many times as we want because we've got lots of clients that we represent. We can afford to lose these claims. They can't.
Right.
And so they have to make a decision that's right for them. But we certainly lay out the parameters and tell them what the risks are, and we give them some things to think about. And one thing that I always say to people is it's certainly risky to go to trial. That there's no doubt about that. But sometimes the riskiest thing you can do is accept a bad offer because you're going to have to live with that bad offer for the rest of your life.
And what is the success rate at trial, Kevin? There's risk, and I'm sure not all cases are successful, but what is the success rate?
That's a very difficult question, Alan. Much of the time when you're going to court, you might be arguing just over the amount. It might just be how much you're entitled to. Other times it's a win or lose proposition. Are you entitled to coverage or are you not? You only end up in trial if you're confident that you've got a good case. And in terms of the actual success rate, I would expect that it's a high one, but I couldn't actually put a number on it.
And Scott, if a trial is threatened, and again, this speaks to the reputation of a company like Murphy Batista, because again, if there's this, oh my goodness, they're serious this time, they're going to go to the wall. As soon as that becomes evident to the opposition, in this case, an insurance company, do they back away a little sometimes when threatened with the reality of, okay, we're not in the least bit concerned, we'll happily take this to trial, no problem?
Well, I mean, they're pretty good poker players.
Right.
So they don't start trembling when we walk into the room. They're seasoned poker players. These are big, powerful companies with very, very good lawyers representing them. So if they're afraid, they certainly don't show it to us. But we can gauge how they respond to us based on how they resolve our claims. I mean, I think we did a tally a couple months ago. I think in the last 7 or 8 years, our firm has ran over 100 trials, which is a lot.
Yes. So
they certainly know that we will go. And if we go and you've got a case that's built on truth and reality, and you've used good judgment in assessing that case, and you've got good experience and skills as a lawyer, your client's probably going to have success. Mm-hmm. And if you're willing to go and seek that remedy for your client, the insurance companies know that they do react to that. When I did work for insurance companies, the first thing they wanted to know is, who's the lawyer? Will they go to trial? Are they any good?
Oh, okay.
So they do ask those questions.
So that's how they assess. That's part of the assessment of how we're going to treat this particular file.
It is, yeah.
Who's their lawyer, and how good are they?
If they know you're not going to take it to trial, then they can offer a lesser amount and wait you out.
Right. So all the more reason, friends, if you are in a situation, especially when you've been offered a carrot, like our producer Art was in his little car accident, he took a couple $100 and he was happy about it because he wasn't wounded. He wasn't severely damaged by the whole thing, fortunately for him. But in a lot of cases, there's a small offering, and a lot of us are inclined to, oh, what the heck, it's like free money. Except, wait a second, you may be entitled to a whole lot more. So again, even if you're offered a carrot, Kevin, might that be a good enough reason to sit down with a lawyer and go, well, should I take this or what?
You just talk to somebody first to find out if it's a reasonable amount.
And that's not going to cost you anything to say, look, I've been banged up in an insurance a situation here. I'm up against an insurance company. They've said, here, we'll cut you a check for this much, Scott. And so you're not going to charge me to say, that's not enough. You shouldn't accept that check.
Well, if the insurance company says, we've accepted the claim and here's what we're prepared to offer you, often what we will do is, rather than have the client hire us, we'll arrange for them to hire an independent insurance adjuster to fight about how much ought to be paid.
Oh, because then it's dollars and cents, right?
Yeah, because quite frankly, often these private insurance adjusters, they can do a better result for the clients and much cheaper than a lawyer can when you're just fighting about how much. Mm-hmm. So often people, they don't need a lawyer. They probably need a private insurance adjuster. They're better, they're cheaper at determining how much in most cases.
You're listening to You and the Law here on AM 650. In studio, Scott Stanley and Kevin Gorley from Murphy Batista, online at murphybatista.com. I'm Sterling Fox. More to come after this.
There's more of the show still ahead. This is You and the Law on AM 650.